Okay, good morning, everyone. For those of you who attended our first webinar, welcome back. And for all of our first timers, welcome. My name is Robert Tauber, and I am the Regional Vice President of Operations for Southeast Florida. On behalf of Vesta Property Services, I would like to thank you all for taking the time to join us today for our second webinar centered around the COVID-19 pandemic. Today's discussion will be centered around preparing for and navigating through the ever-changing ordinances, both statewide and local, your association powers as they relate to those ordinances, and the reopening of your community amenities and routine operations. Partnering once again with Vesta for this webinar is the Law Office of McCabe Ronsman. Many of you may remember two of the firm's partners, Ed and James, from our first webinar. For our new attendees, McCabe Ronsman is a full-service law firm representing community associations throughout the state of Florida. Ed is board certified in condominium and planned development law, representing associations throughout the state. And James provides legal counsel in contested litigation to community associations and developers throughout the state. So once again, it is my pleasure to turn over the presentation to Ed and James.
Thank you, Robert. Thank you, everyone, for attending. What you'll find if you've done this before with us for Zoom, if you look on the bottom, there's a Q&A button that you can click to type a question out to us. We'll be happy then to take a look at that and then either try to answer it when the subject matter is up, or what we've been typically doing is holding the questions mostly to the end. So please make sure to stay till the end on this because we've had some good questions and we're happy to help answer them for you and as best the way we can. Understand that we're providing general information, that it's going to depend upon your community, some specifics that would need further review for your community specifically, but we hope that you'll find some worthwhile information from us today, some of the things that we've seen as attorneys and advising our clients over the last month and a half, and where we see things going forward. So what we're going to be doing is I'm going to be sharing this PowerPoint here. Let me see, I'm going to click right into it. All right, so we'll be going through this PowerPoint today. At the end, we'll have our contact information on this. If you'd like to get a copy of it, feel free to email us. I'll be happy to provide you with a PDF copy of the PowerPoint. We're also, you can probably see there's a little recording button right now. We're recording this, and Vesta is going to be making this recording available for anybody that couldn't attend today. If you have any other board members that couldn't attend, so we're happy to make that available for you. Thank you again to Robert and to Vesta for organizing this, and I think it's a great commitment to you as managers and board members to staying on top of what's going on, us providing you whatever legal guidance we can on this. Obviously, it's some unprecedented times, and what you're going to hear from us today is the way that we interpret these executive orders as best we can, the state of the law, and really a lot of practical guidance on this from a liability standpoint that you're going to find from us. What you may not find from us today is a concrete black and white answer on some of these things of should I do this, should I do that? Because of the novelty of this, it becomes difficult. The best thing that we can do is take a look at what we have and give the best advice possible as to if you want to take this action, this is the way that we would maybe recommend that you look at communicating to your residents or notification, signage, that kind of thing. So we'll be going over that with you. So some of the topics we're going to be talking about, the current orders that are in place. Jim and I are going to be going through that. Jim's going to talk about the state executive order that's in place. And then we have, I know for this region of the state, we will have links to the Palm Beach, Broward, and Miami-Dade current orders that are in place. And we'll be sure to share those on the screen. There's a link in this as well that you can click on later to take a look at the actual executive order. We'll talk about reopening amenities in the community. And then any contractual issues that we've seen, a couple instances that have come up, and then what are the long-term effects? So going into the current orders, Jim, if you want to talk about the current executive order with the phase 1 reopening, understanding that I know you have in here and one of the slides as to the applicability for a lot of the people that are in the webinar today.
Right. So many of us participating in this webinar today. So this is part of a three-part statewide series. And the executive order issued by the governor of our state applies throughout the state, but you also have local orders that apply to each of you, depending on the county that you're in, that will be a little more narrowly tailored to your particular jurisdiction. But statewide, we have Executive Order 2112, the Phase 1 Reopening Executive Order. Again, this is from Governor DeSantis, and has statewide application. And looking at that order, there are three main issues that we saw that primarily affect community associations. There are some other contents of that order, but we really think that three issues will really pertain to you. So the amenities, vacation rentals, and preemption, which is the issue of whether this executive order supersedes orders from local governments. So the first issue we'll talk about is the issue of amenities, such as your gyms, fitness centers, and pools. So the state executive order does not require amenities of residential buildings to be closed. But again, you must review and understand your local government orders. Executive Order 2112 extended a prior Executive Order 2071, but from a statewide standpoint, that executive order did not apply to gyms, fitness centers, or pools, which are an amenity of a residential building, which will likely be most of the amenities that you all have. Again, still talking about statewide application. Now, the issue of whether the association is legally obligated to close an amenity and whether it should close an amenity are separate questions. So then we'll go to the issue of vacation rentals.
And actually, Jim, what I had put in here, if we can, let's take a look at these real quick, and I'm going to share. Let me see. I'm going to share our screen to go through the local orders. So first, we'll start with Broward County real quick, because I think that really details, and I know that there's an exemption based as to Broward County, Miami-Dade, and Palm Beach County. So let's take a look at what we have here for.
Right. So in the governor's order, he expressly stated that his executive order does not apply to these three counties that we're going to talk about. So that the local governors, the mayors there can make and the governing boards can make their own decisions for those parts of the state.
So this is the emergency order for Broward County. It says that pool decks and pools, whether of a commercial or non-commercial nature, shall remain closed pursuant to the emergency order, except that it says that it does not apply to recreational pool amenities that are required for the conduct of an essential service or located on a single-family residential lot, a single townhouse unit, or any duplex lot, provided so that it's utilized only by the inhabitants of that lot or unit. And really for everybody in here, though, at least if you're in a townhome with a community pool or a condominium with a community pool, it says the above referenced closure also does not apply to pool decks or pools in multifamily housing developments, condominium hotels, or single-family HOAs, which are collectively defined as housing developments. And then, but provided the following conditions are met: that you have 6-foot social distancing under CDC guidelines, and the pool occupancy is limited to no greater than 50%. And then you either must have somebody basically on staff supervising it to make sure that there's compliance with this, or you're required to remove all furnishings from the pool deck. So any use of the pool decks or the pool areas that deviate from the CDC guidelines or the requirements remain prohibited. And then for further amenities, it talks about basketball courts, tennis courts, and other recreational amenities that are located within housing developments may be open for exclusive use by residents. And I thought that residents was an interesting term, because the question is whether or not in Broward County, what if you have a guest? If you have a guest that comes in your community and wants to use some of those amenities? Arguably, whether or not it was intentional, it says residents as opposed to residents and their guests. So there may be an issue there of whether or not you're allowed to bring in guests, for example. So that's what we have for Broward County. Let's take a look at Miami-Dade. Miami-Dade is pretty much, if you go down here, it says all pools, hot tubs, and fitness centers, gymnasiums, whether of a commercial or non-commercial nature, are closed for all purposes. But it does say that it's not applicable to any amenity located on a single-family residential lot, or if you have something directly, basically adjacent to your townhouse, duplex, or villa, which is for exclusive recreational use of the inhabitant of that individual unit. So if you have something coming right off of your townhome or your villa or a duplex that only you can use, it's basically still closing down all of the community pools. You then have, that's for the pools, fitness centers, gymnasiums. You then have to go to the other order that's in place, which requires further analysis. It talks about, I'm thinking about tennis courts and basketball courts or any other amenity that you might have that wasn't subject to that other order. Let me see here. I know we saw something in here that it limited it to single tennis play may be allowed. So organized or competitive play on courts and fields is prohibited, except single tennis play may be allowed. So you have some fairly detailed here regarding certain amenity use, and even if it might be open, mean, I suppose you could have the basketball courts open, but for somebody practicing, as opposed to playing one-on-one even, or having an organized like a 3-on-3 pickup game or something, that might still be prohibited, as opposed to singles tennis play. So obviously, a little bit more restrictive, of course, from Miami-Dade, and we got to take a look at the local order that's in place there, and talk with your manager, talk with your attorney to make sure that you're in compliance. We're happy to assist on that, of course, but really it's going by a local order, county by county standpoint for most of the people that are in this webinar right now. And let's see. And then we have Palm Beach County. And here, basically Palm Beach County is following the Broward County. All tennis and outdoor racket facilities, as well as community pools, shall reopen. As set forth in attachment 5. You got to go down. Let's see here. You have to go down to attachment 5, which is loading. And it basically says the same thing, where it's 50% capacity, and you have to have somebody there that's monitoring the pool deck, essentially, to ensure compliance. So if you are choosing to reopen your amenities, and we'll talk a little bit more about that, of whether or not you should, be aware, especially for Broward and for Palm Beach counties, that there is a requirement that it be monitored to ensure compliance. It says 1 or more facility staff or management must be present at each facility location to monitor and ensure compliance with the restrictions within the order. All right, so let's get us back to the PowerPoint here. All right, so Jim, if you want to jump back in then on the vacation rental side here.
Sure. So jumping back to statewide orders of statewide applicability, the Governor's Order, Executive Order 2112, extends the prohibitions on vacation rentals as provided by the previous Executive Order 2087. And what that order did was prohibited parties engaged in the rental of vacation rental properties, as defined by a statute, from making new reservations, with some exceptions. It also provides that the prohibition shall include the rental of any house, condominium, cooperative, or dwelling unit that is also a transient public lodging establishment, as that term is defined by statute. And so here are some exceptions: rentals to persons performing military, emergency, governmental, health, or infrastructure response, or travelers engaged in non-vacation commercial activities, which that term is not defined anywhere. But those are not prohibited by Executive Order 2112. So then we have to look at how these words are actually defined to better understand what exactly is prohibited. So a vacation rental, that term is defined by law, and it's a unit or group of units in a condominium or cooperative, or individually or collectively owned single-family, two-family, three-family, or four-family house or dwelling unit that is also a transient public lodging establishment, but that is not a timeshare project. So then we have to look at the definition of transient public lodging establishment. Basically what that comes down to is if there are rentals of more than 3 times in a calendar year for periods of fewer than 30 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place regularly rented to guests, then you would qualify under the definition of transient public lodging establishment, and that rental would be prohibited if it's for fewer than 30 days. So to summarize what really all of this means is, if the rental is to an exempt person, or if the rental is for fewer than 30 days or 1 month, but the unit is not rented for more than 3 times in a calendar year for periods of fewer than 30 days or 1 month, or if the rental is for a period of greater than 30 days or 1 calendar month, then the governor's order does not prohibit that rental. However, it's important to understand that that order does not permit a rental that is otherwise prohibited by your governing documents. So for example, if your governing documents say that all rentals must be for a minimum duration of 6 months, then this executive order wouldn't provide any exemptions to what's otherwise required by your governing documents.
Yeah.
A couple of final points on vacation rentals. If the association doesn't have tenant or lease approval authority in the governing documents, then this executive order doesn't otherwise grant enforcement powers to community associations. In that case, it's not the association's role to attempt to enforce executive orders or law. Contact law enforcement for that. In addition, if the association does have tenant or lease approval authority, or if there's a compliance with law provision in the governing documents, your association may have the option of either contacting law enforcement if they believe that the executive order has been violated, or you could potentially institute covenant or rule enforcement proceedings, or a combination of those things. Now, which one you want to pursue if you believe there's been a violation of that order, you want to work with your legal counsel on. We try to recommend the free options for you. So we would likely recommend contacting law enforcement first, because you don't have to pay us to send letters and institute formal proceedings. See if the state will enforce its own order. And if not, we can consider your other options.
The other thing, that's the more immediate action that you can really take. Right now, it's really difficult. Under other circumstances, if you had a specific issue to your community that required immediate action, you could file for an emergency injunction with the court, and you might be able to get hearing time. Right now, we're not getting any hearing time on this. It's basically, it's closed unless it's for critical services, which mostly are related to criminal proceedings in terms of the courthouse right now. And so in terms of any immediate action that you can take, I equate this to if you didn't have COVID-19 going on and you had somebody that was trespassing in your community, we would never give you the advice to go down there and try to physically remove them or prevent them from coming in. We would tell you to call law enforcement. The same thing is with this, where if you feel like there's a violation of the order, call law enforcement, see if they will come in and react to it. In terms of anything the association can do, in a second bullet point here, you talk about whether if you have a compliance with law provision in your governing documents, that does provide you with the option of sending out a demand letter, perhaps the ability to establish a fine by the board that has to then be approved by the committee of 3 or more members that aren't on the board. And that, at least the threat of that, might result in them stopping with any activity that might be going on. But really, that's a down the road option. I've worked with some communities, even if you have a gate. I've had some communities where I advised, hey, be very careful, because what they were saying was, hey, if this looks like it's in violation of the governor's order, we're just not going to allow them access into the community. I said, well, remember that owners have easement rights and their guests have easement rights into the property. And so to take that away, we have to have a pretty good reason. It has to be spelled out in our documents. And so what you'd be doing is you're piggybacking off of the compliance with law provision says that we're piggybacking off of the governor's order or whatever your local order is. And you run the risk of whether or not some of those orders are constitutional or not. And we're not going to spend the whole time on this talking about that constitutionality, but there are some concerns with it. And we've seen some concerns raised, especially by the rental agencies in the state that have been arguing, why are the vacation rentals being singled out and being prohibited, but hotels are allowed to remain open? And so there are some letters that have gone over to the governor and to the state attorney general from some of the larger rental agencies in the state that there could be an action that could find whether or not, if this continues to go on, whether such action was constitutional. And if we use that as a basis for considering to be a violation of our governing documents, and that law is found to be unconstitutional and inapplicable, then guess what? The association is going to have some liability there, and there's an attorney fee provision if you don't prevail on it. So just be careful about trying to use that as a way to enforce your covenants by saying that there's a compliance with law provision. You'd want to have that be able to do in the first place, but really talk to your legal counsel before you go forward with it, just to understand. It comes down to a risk tolerance. For that association I mentioned, they've been relatively aggressive. They have some restrictions as to rentals in the first place, and they've taken the position that they are going to deny access through the gate. I've advised them of that before, so that's a little bit more of an aggressive association. It just depends on the risk tolerance that the board has on this stuff. So before you go forward with that, just understand you have to have authority in your documents to even enforce it, and even then, be careful about how you're doing it. And like Jim said, contacting law enforcement is the cheapest option and the more immediate option to try to get some relief if you feel like it's in violation.
And the last issue that is contemplated by the governor's order that I think pertains to associations is the issue of preemption, which is the question of whether the governor's order preempts or supersedes local law. So unlike Executive Order 2091, which was clarified by 2092, nothing in 2112 expresses an intent to preempt or supersede local law. And also, most of Executive Order 2112 expressly does not apply to Miami-Dade, Broward, and Palm Beach County, because the governor wanted to allow the local governing entities in those jurisdictions to manage the issues associated with COVID-19, more particularly in their jurisdictions, rather than mandate something from the state. There are also frequently asked questions attached to the governor's order, and it states that local authorities are allowed to adopt requirements directly on businesses, operations, or venues, including buildings, beaches, and parks that are stricter than the governor's orders. So the bottom line is that the associations must review their local law, including local executive orders that are issued by local governing authorities, and determine whether and how they must comply with them.
So, and I went through that before. We had the links to Miami-Dade, Broward, and Palm Beach counties. You really need to take a look at those obviously for a lot of the people that are in this webinar this morning. I think I had a question from Dawn. It was a two-part question. It says, if we remove the chairs, lounge chairs, and move the tables to one area and rope them off, would that meet the intent? And then the question is, then what do you do if you don't have facility staff or management in your community? So I know it depends on which county you're in. I know that at least for one of the orders, it said that you can either have it staffed or you can remove all of the pool furniture. I have to see if that was the case. Also, I think that was for Broward County. I have to see if that was the case for Palm Beach County. So by removing it, if that's what the executive order requires, I think that would meet the intent and the requirement there. Whether if you rope them off, are you required to physically remove them so nobody could even see them and bring them out? I mean, that it doesn't go into that much detail in the executive order. I think that if you were to stack it up and have it roped off saying not available for use, that probably would meet the intent, I would say, of the executive order. But yeah, if you aren't able to do that, or if you're in and I need to check that again, and we can maybe circle back on that later, that requires you to have somebody there staffing it, that would be something that the association would need to consider as an expense. It's another difficulty if you were looking to reopen or have them open. There are still some conditions placed on it. We found that more to be the case in Southeast Florida, where most of you are on the webinar today. So it's really taking a look at your local order and making sure that what you're doing is in compliance with that. All right. All right, so reopening the amenities, we've really gone through a lot of this. And the question is, can we reopen? And it depends on your local orders that are still in place. But the question then is, well, should we? And unfortunately, we can't tell you, even if you have an ability to do so, let's say in Broward or in Palm Beach counties, for example, whether or not you actually should. I think that what we've been advising our clients is there's certainly grounds to support it. I say that reopening it, obviously the grounds are it's an amenity that's available for the use by their members and guests. It's a property right that they have in terms of what's available in terms of easement rights within the covenants. It's one of the base functions, I would say, of an association that has amenities is the access for members to be able to use it and the board's ability to administer and operate those. So I certainly think, of course, there are grounds to reopen it. If you choose to do that, what we've been advising clients is to notify the residents that using it, even within the allowances that are available right now in terms of limited capacity, is you're using it at your own risk. You need to abide by CDC guidelines, and that the association's not responsible. It doesn't warrant, it doesn't undertake the effort to prevent the spread of the disease or any other liability associated with it. Basically what it's saying is, please don't expect us to be out here wiping down everything and trying to prevent the spread of this disease. It's not something that's within the board's obligation, nor do we really have the ability to do it. And we don't want to create that expectation, because if you do create that expectation and somebody, I think the idea would be, boy, everything's reopened and they said that they're looking out for my health, safety, and welfare. It sounds like they've got things under control. I'm going to go out there more than I normally would. And then what if somebody contracts it? Now, proof is still another difficult standpoint. If they've gone to the gas station once, you could say, well, how do you know you didn't get it at the gas station or the grocery store? But the fact that if they've been limited to really community use, for example, they may have a cause of action against the association to say, you failed in your duty. You undertook this duty to prevent the spread of the disease, and you failed in that because I contracted it.
Yeah, and similarly, in jurisdictions where you have to have one staff to inspect the facilities and clean them and so forth, that might not be a disclaimable duty. So if you don't have someone there complying with that order in that local jurisdiction and, wiping things off, or someone could argue that they were doing it negligently, right? So I don't know that you can disclaim a duty in that circumstance where opening your amenities has conditions that are imposed by local law to actually sanitize and clean things and monitor. I think in those situations, you have even a little greater exposure, because there are, at least to the extent the orders are constitutional, there are obligations by law imposed for you to do those things specifically. In areas where the local governments aren't mandating that you have to clean and sanitize and do certain things if you choose to open your amenities at this time, there's a little more room for argument and debate. So what Ed's suggesting is that if you choose to open them, first of all, if you're allowed to open them and you choose to open them, include some disclaimer language in your communications to residents, post flyers, post that offer the CDC guidelines and recommendations, regarding social distancing and otherwise. They can be obtained from the CDC website. The idea is to not create the impression for members that you're protecting them, that you're looking out for their safety. Of course, you might want to do that, but you don't want to communicate to them in a way that exposes your association to liability.
The other thing going along with that is I think it's perfectly appropriate, and a lot of communities have increased their cleaning, their sanitation schedules, janitorial services. That's all perfectly appropriate. I would go so far, maybe I don't know if I'd say I recommend it, but I think that it's certainly within the scope and the ability of the association to do it. The main thing that I've been advising clients is I wouldn't go out then and advertise that you're doing that to show that you're trying to prevent the spread of the disease, because then it makes it look like you're undertaking that duty to prevent it. Whereas, hey, if you're going to do it because the effect is to, prevent the spread, and if you're not conveying that, hey, we're in a safe haven here, feel free, it kind of has the effect of owners are really thinking of, okay, do I want to go out and use these amenities? I know that I can, but I need to be safe. I need to have hand sanitizer with me, or if I want to bring my own wipes to wipe down the handles before I touch them and after I leave, that kind of thing. I think it has the effect of keeping people safer than if you say something like, come and use our pool, everything's great, we're wiping everything down, and then what happens if somebody contracts the disease? That's the difficulty that we see with it. On the flip side, though, if you choose to keep your amenities closed, which some of our clients that we work with have done that, I certainly think, I think that there's a defensible basis for it. The question is, like we said here, the board has broad powers over the administration of the common elements in the common areas. You have certain emergency powers under the condominium and the homeowners association, the cooperative act. There's some debate as to whether or not those emergency powers apply in the instance of a pandemic, as opposed to really the way that the statute is worded is that it's regarding property damage. There's been some interpretation that's come out from the Division of Condominiums, Timeshares, and Mobile Homes, which is effectively stated, we consider the emergency powers here to apply. The problem is that the division doesn't have jurisdiction over HOAs. They only have jurisdiction over HOAs as to really election issues. So then if you're in a homeowners association, whether you're a single family community or a townhome community under Chapter 720, that interpretation doesn't really apply. And even then, it's an interpretation of the division. So we just say, we think that there's a basis for using those emergency powers. There is some risk associated with it, that if somebody wanted to challenge you, they could say, and you actually have to get in front of a judge and an appellate court or a trial court judge, and then it would potentially go up on appeal, that might say, no, despite what the division said, we don't actually think that this applies, and so therefore you might not have the ability to completely shut down the amenities. There's been some debate on our listserv. We're on a listserv with hundreds of condominium and HOA attorneys, and I just saw an attorney just recently say, I think the board has the ability to shut them down regardless of the emergency powers because of the broad administration powers and the ability to oversee. And I think there's some argument to it. Just know that it's not a clear cut, this applies in a pandemic, and yes, you are able to completely close the amenities for as long as the board wants. I think there's grounds to support that position, but it's not black and white. So, the downside to keeping them closed is that you're going to have angry owners that say, what am I paying my assessments for? I bought into this community because we've got a great pool, we've got great amenities, and I think that you can open these in a safe way that allows us to still use those on a limited basis. And that's certainly a valid argument to be made. I think that there's a valid defense to that by saying, hey, it's our job. We're going about this. We're relying upon the advice of healthcare professionals that still recommend trying to close anywhere there could be prevented the spread of the disease, something like that. And I think there's a basis for the board doing that. Do you have any other thoughts on that, Jim?
And I think there was a question, yes, people pay assessments in part for maintenance of the amenities, but the association's decision to close the amenities does not give people an excuse to not pay assessments, okay? The excuses for non-payment of assessments are extremely limited, at least in Florida they are. So no one can condition or withhold payment of assessments because the association decided to close an amenity. That's not an excuse for non-payment.
There's a case on this that typically comes up outside of the pandemic that's going on right now. What most frequently comes up is there was an owner that had water intrusion into their unit. They said that the association was negligent and failed in their duty to maintain the roof and the exterior of the building, and so they stopped paying their assessments. And the court said, no, that's not an excuse. You have to pay your assessments. What you need to do is file your own lawsuit or a counterclaim in anything. So you need to still pay your dues. And then if you feel like there was some breach of the obligation of the association, you have to bring that as a separate lawsuit. So I think that would apply here in the same instance of, I'm going to stop paying my dues because you're not allowing me to use the amenities. No, you have to pay your dues. And then if you feel like you have a cause of action, you need to bring that against the association separately. So anything, we talked about this, notice to owners, any communication provided to the owner should be carefully worded. Talk with your manager, really talk with your attorney. I've done this for a lot of our associations. You want to have the right wording in there where I understand you want to have the effect of, hey, we're in this together. We're all part of this community, but we want to have this disclaimer language that says, look, ultimately, if you choose to use the common areas and amenities that are open, that you do so at your own risk. And please understand that we do not undertake the obligation to prevent the spread of the disease. We're not taking on that duty. And I think it's just a way to keep people from feeling like you're out there wiping I always give the example of wiping down the elevator buttons after every time somebody uses it, or wiping down railings after every time somebody touches it when they're going up the stairs. That's not your obligation. You don't want to make it seem like that you've taken on that duty, because then again, if somebody contracts the disease, they could try to say that you failed in your duty there because you didn't ramp up enough, sanitation efforts. So that's basically it from a notice to owners, is just really making sure you have the proper language used in the communication to the owners. We recommended sending out something like doing an email and a mailing blast to all your owners, and then following it up with certain signage at the amenities that might be reopened or available to use, just so that there's no question about whether or not somebody was provided a copy or that it was available for them to see right when they're about to use the amenity, for example. Vendor access has come up, and some of you may have had this within your communities. There's potential liability for not allowing vendors. There's contractual damages that are incurred by owners. Owners have contracts for these vendors or anybody that comes in that's providing services. And if you fail to allow access, if that owner is out money, if they're damaged in any way, there could be a liability on the part of the association. The other thing that I bring up is, what if you're preventing access for somebody that's providing some type of a product like a medical service or something like that, and you do not allow access into the community, and then there's a health issue. God forbid somebody dies because of that. You can imagine that that's a clearer cause of action, I would say, from a wrongful death standpoint, than if you had allowed somebody in that you're not sure if they even had the virus, and whether or not you can actually prove that that was the person that caused it within your community. I understand it's a balancing act and you want to protect your members, but I think that closing down the community to outsiders contains a lot of risk. And even if you were to do that, I think you'd want to craft a way to maybe have some process for applying for a variance or an exception basically to it, so that at least you have a process for kind of going through it. And even then, if you're granting variances, you want to make sure you're treating people similarly to that. So just be careful of that from a vendor access standpoint. I think that that's been loosening a little bit. I saw that happen right away where this all happened, and it was really in March, at the end of March, where people were like, we're shutting down our community, we're not allowing any access, especially for condos because it's more in close quarters. I've seen some loosening of that, but just be mindful of the potential for liability there if you continue to do that. Talk with your attorney, look for the best way to handle it if you are choosing to go that route, because there are some potentials for liability, and at least you want to provide notification and handle it the best way possible. All right, so some contractual issues that we've seen. Talking about vendor agreements or agreements that the association is part of with any vendor for service, we've had some communities that have been going forward with some restoration or long-term projects in terms of exterior painting, or I could see it, of course, in a condominium context for any interior work that might be going on in any of the common areas. And the questions come up, Ed, can we go to those people and say, we want you to limit your crew, we want you to make sure that they're wearing masks and gloves and that they are having temperature checks every day? And my response is, it's very difficult to require that as part of the contract that you probably have in place. When those contracts are entered into, now it's something to think about if you're entering into contracts right now for services that you want to keep moving forward with any projects that you have, that I think now is a good opportunity to consider, okay, I need to add a clause in here regarding maybe I can't fully dictate work all the time, but if there's a limited instance where it's to protect maybe the health, safety, and welfare of our residents, or if the board feels like they're doing that they can require some type of action to be taken by the vendor, try to ask for that to be included in the contract. But if you don't have it right now, it's difficult to be able to require that. Could you send out notification? Jim, let me know your thoughts on what if you send notification to vendors that refuse to do this, and you say, look, we've asked you to do that, you refuse to comply, and there could be some liability. What if somebody gets sick? How would you handle that, maybe from a notification standpoint?
Yeah, well, in the first place, if we can control the liability and risk allocation and the construction contract in the front end, that would be ideal. And you as the association, you have the money, and that means you have the bargaining power. So, a lot of clients, if the contract's like, oh, it's only a $50,000 contract, I'm not going to go send it to a lawyer. They're going to charge us a bunch of money. Well, the money you pay the contractor might be 50 grand. The amount of liability you're exposed to might be millions, right? So it's still important to allocate risk in your contract. So if you can get on the front end to do that, that's great. And what I mean by that is having the contractor indemnify, defend, and hold the association harmless very broadly for liabilities that can result from the activities of that contractor. Aside from that, I think from a practical standpoint, even if you don't have a contractual basis, to have some construction implementation guidelines, which is where you might have put some of the stuff about, hey, your crew members must have masks, whatever you might want to do to address COVID-19 and the circumstances. If your contract doesn't provide the basis, if you're in a jurisdiction where the local order might require some of those things, well, then I think you can point to that. But otherwise, I think you can rely on some practical aspects of your association. These vendors are going to want your business in the future. They're going to want to have good relationships with your management company so they can perhaps get in with other communities. So you might have practical leverage to try to implement some of these reasonable measures if you'd like to do that.
Ask them to provide you with what is their company protocol, what's their procedures for ensuring the health, safety, and welfare of their workers, and to show what actions they're taking to make sure that, obviously, the business owner is concerned too. They don't want to have this virus spread and have all of their crew members not be able to work, for example, too. So they have a business incentive to make sure, and they probably have procedures in place. Ask for them to provide that, and just ask them, hey, are you committed to making sure that that applies for the project that you're working on for our community? If you have something like that in email and writing that you have, I think that's a good basis for the association to use later if they deviate from that potentially. The force majeure issue, there's been some questions about this. Has been a good subject of debate to determine whether or not a pandemic applies, or force majeure applies when there's a pandemic. The first thing is generally the performance or delay in performance of an obligation under a contract can be excused when it's impossible, impractical, or financially infeasible. A force majeure serves to excuse performance as a result of an act of God, war, strike, riot. But the main thing is this third bullet point, which means that a force majeure clause has to be specifically provided in the contract. It's not implied. It's something that has to be explicitly provided. And the specific wording is important as to the event. There is some case law on this that says that if you have to, it's not one of those things that says, for example, it may include this. It has to say it must include these items. So if you don't have the word pandemic in there, you might not be able to have that applied. Now, you could have some broader language, Jim, and we talked about this another, maybe you have a little more broader language than just using pandemic, or perhaps maybe it's because of any type of state, federal, local ordinance or something law in place that prevents them from doing the work, for example, in response to some type of activity. That could apply. So the main thing, though, is there's not a catch-all type of advice that we can give, except to say that it really depends on what's in your contract. The other thing is that in the context of community associations, force majeure clauses typically are only come into play when it's the vendor or the entity that you're contracting with that's providing a service if they're unable to perform, rather than the association being able to get out of it. There are limited instances where the association may want to. I bring up the example of, if you had just signed off on doing a big painting or a restoration project and then a hurricane comes through and your buildings are torn down, obviously that makes it impossible, and if you have a force majeure clause in there, you're not going to be required to perform under the contract and pay this vendor for work that they're not able to do. There's an impossibility there. So that might be a way to get out of it. But for the most part, this force majeure clause is going to be if you're contracting with somebody that they're the ones providing service for your community, and really your only obligation under the contract is to pay them. It's likely to be them that will say, hey, we can't get this work done in the time period that we're required to. Maybe you have a liquidated damages provision if they don't complete the project by a certain date. That may excuse them from performance. So again, it's taking a look at the agreement and seeing what specific language applies. And again, drafting and contracts going forward, take a look at that. I think that you're going to see a lot of inclusion of pandemic language in force majeure provisions. Associations are really looking at their insurance policies as well and whether or not they have coverage that covers under a pandemic event. So you're going to see a lot of this that's going to be it's going to be fresh in everybody's minds. You're going to see a lot of this going forward in contracts and policies going forward, I think. Yeah. All right, so what is the kind of finishing up on our last section here, what are the long-term effects that we can see? Collections and financial issues. And I want to go back. Don had a question kind of piggybacking on an earlier one, which is we have a resident that says they will reduce the amount of the HOA assessments they'll pay because of lack of use. Would the advice be the same as non-payment? Yes. Same thing. They can't reduce their assessments because they feel like, well, my dues are $400 a month for this condo, but you know, half of the budget items go towards the pools and the amenities, so I'm only going to pay $200 a month. It doesn't work that way. You have to pay your full assessments. So that's a good question, but stay firm on that. And in terms of talking about collections and financial issues, you're going to see it's going to be probably a couple months down the road that you're going to see the effects of this, because people losing their jobs, and eventually if they aren't able to regain their employment, or if there's issues with unemployment benefits, you know, running out, or whatever that may be for their income versus what they were getting before, there may be some hard decisions to make for owners of paying their assessments. So I think this is going to be an issue that we're going to see, maybe not to the level of the housing crisis from 10 plus years ago, but I do think that there's going to be an issue with this. And what we're advising associations that we work with is to establish a collection policy for the objective handling. That can be, we're going to send out a reminder notice with this many days to comply, maybe a late fee notice, and then on this date, you know, whatever it is, 60 or 90 days from the first delinquency, we're going to move forward with an intent to lien letter, for example, and have it set out as an objective policy so that it's helpful for your management company. I know that, because they don't feel like they have to go and ask for permission on every single owner that is not paying their assessments. They know that once they reach this certain phase, that it's for the next step in the handling of it. And I think it allows for more efficient handling of it. We've recommended against any type of waiver of payment of assessments or late fees. And Jim, do you want to talk about that a little bit, just with the reason for that?
Yeah, so what we're saying by that is, you know, there's going to be some room for sympathy and understanding, but what we don't want to do is have a prospective waiver of assessments, late fees, or interest. First of all, there are statutory limitations on a condominium association's ability to waive assessments. Essentially, there's a statute prohibiting the association from waiving assessments, unless they do so uniformly, perhaps. But we don't want to do anything on a blanket basis on the front end. What we want to do is establish a consistent collection policy, and then if owners contact you and say, hey, I lost my job because of COVID-19, but I can offer a payment plan over this number of months. Can you give me a break on the late fees and interest? That's the type of conversation we want to encourage rather than a blanket-wide basis, because some owners inevitably are not going to be able to pay, and they're probably going to be foreclosed by their mortgage holder. So we don't want to have a blanket waiver that ultimately a financial institution or a foreclosing lender is going to be able to take advantage of, right? We want to be able to reserve these situations for actual homeowners, people who have experienced some problems. And then we want to also be able to identify whether their problems were really associated with COVID-19 or whether they stopped paying beforehand and really don't need the accommodation from the association. Yep.
So going to the next thing that we are seeing is electronic voting. What I'm finding with this is we've already had a number of associations, maybe a lot of you attending here have had to postpone or cancel your spring annual meeting if there's an election that takes place. I think that we're going to see this, from what I can see going into the fall, I have a hard time seeing us in the fall being completely back to normal in terms of no restrictions. And even if there are no restrictions, maybe if our governor and our local governments lift them, I still think that there's going to be a psychological thing from people of not wanting to gather. And obviously, if you've been to these, you have 50 or 100 people in place at one time. And especially for communities that maybe if there's an elderly community that are more at risk, people are not going to want to attend in person. And so what we've been recommending to some association is, hey, consider adopting an electronic voting process. There's vendors that you can work with that will assist you with it. Even though you still, we're recommending our clients that you still have to have a physical location for the meeting to take place. If people sign up for electronic voting and all you really have to vote on is the election itself, you might get people that don't really feel like they need to show up. And as long as they can cast their ballot electronically, that you're going to be able to get more participation and more people to be able to have the election. So if you've postponed it and you're looking to try to have your election in the next month or two, might be too quick, to try to switch to electronic voting. But if you're in a fall, later on this year, consider doing that now. It's not the most time consuming, but you do want to have some lead time because there's a resolution that needs to be established by the board. you need to provide notification to the membership, and then the members need to opt into electronic voting. So if they don't opt in, then you still have to send them the paper ballot or give them the ability to show up in person, which even electronic voting participants have the ability to. So you want to give enough time to do that. What I found working with vendors is they want to be involved maybe no later than 60 to 90 days from when the election is going to take place. So consider doing that. I think it's a way practically of moving to a standpoint of, if we think this is going to be the effect for through the fall, why don't we go to electronic voting to really discourage people from showing up? And I'll talk a little bit about maybe on the statutory changes. We haven't really fully addressed virtual board versus member meetings, but I'll talk about that in just a second. The other thing too on the bottom here, it's not really the anything that condos need to worry about because you have a statutorily required election process. But for HOA, really review your election provisions, because if you don't have a process for nominating in advance, which means really your bylaws need to say, if you want to run for the board, you need to get your name in by this date, for example. That's really what is a nomination in advance process. If you don't have that, if it's more general in nature where it basically says members are able to run for the board and you have to provide at least 14 days notice and nominations from the floor are required, that's not a nomination in advance process. You still have to try to show up to the meeting and make a quorum, which is 30% or less for HOAs if your members have to show up. If you don't make that, even if you only have 2 people that have kind of notified of their intent to run for 2 seats and you don't even think you're going to have nominations from the floor, if you're still required to go through that process and you don't make quorum for your annual meeting, the previous directors whose seats were up continue to stay on as holdover directors. And so that messes up your staggered terms. So really for HOAs, take a look at what's in your documents in terms of your election process and try to provide for a process. What we recommend is closer to the condominium form, which is, the condominium form is first notice goes out at least 60 days in advance to call for candidates, and then you have to get your name in at least 40 days in advance. It's nice because you have some cutoff periods that I need to get my name in by this date, and then once that cutoff period runs past, if you're going to have your election or not. So really look at your HOA documents. It doesn't matter what your past practice has been. There's an arbitration decision on this as well, where it basically says, even if you've done the condominium form of election for 10 years as an HOA, if that doesn't match with your bylaws, an owner is able to challenge that election process and is likely going to prevail if you didn't follow it, because it's what's in your bylaws that controls. So take a look at it for HOAs especially. So what are the possible statutory changes that we could see maybe coming out of this? I think you're going to see a change to the emergency powers to expand it beyond just property damage. They're going to probably put in language regarding pandemics or any other instances where a state of emergency has been declared. I think we'll see that. Then going into allowing completely virtual board and membership meetings. You don't have that in place right now because if it's based on property damage, it's more based on the board being able to meet in a manner as practical with notice as practical as possible at a location that is safe for it to be held for membership. But there really isn't contemplation in the statute that, hey, we might have a perfectly in-shape clubhouse or meeting facility, but we don't want people to actually show up to it because of the spread of the disease. And so we don't have that right now. We've been advising clients that I think it's permissible to have a virtual board meeting. If you don't have a very large meeting space that members could attend a board meeting and everybody stand 6 feet apart, I've been more amenable to, I guess, recommending that, because it comes down to the ability of the board members. They've always had the ability to vote via telephone or FaceTime or whatever other type of telecommunication process, right? So for me, I look at it as the difference between a board meeting and a membership meeting. That a membership meeting, it's the members that are voting, and it's the members that are really controlling the meeting in terms of from a quorum standpoint and making motions. That there's no process for members to completely vote virtually unless they opt into the electronic voting, but you still have to have a quorum for the meeting, for example, right? And so we've been advising against having a completely virtual membership meeting. I think you still need to have some type of physical location. What some associations have done is say, hey, this is going to be the physical location for the meeting, and we'll have a couple people there to take your ballot and then to count it if we're able to make quorum. But we really ask that you not attend and stay there after dropping off your proxy or your ballot and going back home. And then here's the way that you can follow along either on the telephone or via a Zoom conference, for example. So we could see that coming into play. But for right now, we are recommending we had a question yesterday on this, like, should we be having board meetings completely virtually or can we vote by email? The statute still says that you're not allowed to vote by email as board members. It contemplates still having a meeting in a notice as practical as possible, but it's still contemplating board meetings taking place. And so I'd rather you have a completely virtual board meeting where members can attend and witness that discussion, rather than the board going and conducting all of its business by email, and then the members coming out saying, I haven't heard anything from my board in 2 months. How have you been making your decisions? And the board says, well, we've been emailing about it. I'd rather you have a virtual board meeting where you post notice saying, here's the call-in or the link for the meeting, and we invite you to attend, but this is how we're going to have it. And then the last thing is whether or not there's going to be flexibility with the use of reserves for other than their intended purpose. We've had this question come up a couple times, and there's nothing in the statute that allows it now. There is a provision in the emergency powers that allows you to pass a special assessment, notwithstanding whether or not it requires member approval. It allows the board to pass it, but it's not carte blanche to pass a special assessment for a capital improvement that's not related to, in my opinion, the pandemic that's going on. So even then, from a special assessment standpoint, what we've been advising our clients is if you're running low from an operating standpoint because people aren't paying their dues, maybe it's because it's related to this, that they've lost their income and they're not paying their assessments, you could potentially pass a special assessment. I think that could fit potentially under the emergency powers. I'd be more comfortable doing that than I would just taking money from reserves. You have to have membership approval at a meeting where a quorum is met in order to do that. Any other thoughts on that, Jim, from a financial standpoint?
Yeah, and one of the issues, so the emergency powers, to the extent they apply, give the association the ability to levy a special assessment without membership approval, even if the governing documents otherwise require that. But the problem is, it's a liquidity issue. So if you levy a special assessment and you need money now, you still have to hope that those people pay that special assessment. So if you have liquidity issues, you might need to work with your manager and attorney on that, because a better option might be to get a loan and then have the assessments paid a loan on the back end. So again, you have the money now. Otherwise, to use reserves for purposes other than which they were intended and originally established, like Ed said, you need a membership vote. The only exception potentially is for homeowners associations, and it depends specifically on how that reserve account was established.
Yeah.
It's a little too nuanced and detailed to fully explain now, but generally speaking, don't tap into your reserves. Contact legal counsel before trying to do that.
Yeah. All right, so that's what we have in terms of substance from the PowerPoint. We do have a couple of good questions here, and if you have any that you'd like to kind of get in before we sign off for today, please feel free to type them in right now. I'm going to keep this screen up here for just a little bit as we answer, so you have our contact information. Robert, I know, is the VP for your region here for this webinar today. His email is down here as well. But let's just take a couple questions that we had. Susan asks whether or not, going back to the vendor access issue, is an aide considered a vendor? Really when I mention vendor, it's more of not necessarily just limited to vendors, but if you're trying to limit access to outsiders that aren't owners or, in your community, just be careful about doing that because of the access rights and the easement rights that really an owner has to allow guests and invitees into your community. Just be careful about doing that. So an aide, again, look within that, what's your policy, and if you're disallowing it, and if you are going to disallow that, I would recommend you talk to legal counsel, because I think there's going to be some liability issues associated with it. Usually if it's somebody that, especially if there's a contract in place where money, if there's consideration being paid for somebody coming in, that owner is going to be upset if you're not allowing somebody to come in that they're paying for, or if they're not receiving a service that they're expecting. So talk with your manager and your legal counsel about that before you prevent access from outsiders into your community.
Yeah, that, and what exactly is that aiding? Is he or she aiding someone with a disability? Well, then preventing that person, could subject you to a discrimination lawsuit. So you need to be careful on that.
Next question is from Lynn. Many of our owners are not technologically savvy or have computer access. Any other suggestions for elections? It's a good point, and really it's why it comes down to why you still need to have a physical location for people to be able to come by and drop off. If for a community that maybe if you feel like your residents aren't as technologically advanced, maybe you don't necessarily try for the electronic voting, but you make it clear in your notice that we're going to have our election. We have to have a physical location, but we'd really encourage you just to come in and cast your ballot and drop off your proxy, depending if you're a condo or an HOA, if you might only need to drop off a ballot, for example. But please don't stay for it. Maybe you don't even try for the Zoom meeting where you have to have, the software. Maybe you just set up a conference call that has the capability to have all the people call in. That's probably the easiest way from a technology standpoint to say, dial into this 1-800 number and use this passcode.
Yeah. Another thing is, if, I don't know whether you're a condo or an HOA, the person who asked the question, but generally speaking, if the goal is to just get your election accomplished, you can essentially do that by mail. So long as you get 20% of the ballots, again, if you're a condo or if you're an HOA who has adopted the condo form of elections, all they have to do is mail in a ballot. So they don't have to physically attend. You don't need to attain a quorum if you have those election procedures from the condo side. So you can still accomplish your election even without using technology by people mailing in their ballots.
Right. Don asks, can committees vote virtually, for example, an architectural review committee? So for HOAs, architectural review committees that are making a decision, actually it's not even making a decision, it's really any architectural review committee meeting, as I review the statute more, has to be noticed and open in the same manner as a board of directors meeting. So anything that we've said about virtual board meetings, providing notice and an opportunity for people to attend would also apply for architectural review committee meetings. You don't want to have these decisions being made. You probably are going to have, I'm sure in a lot of these architectural review committee meetings, you might be making a decision on somebody's property and their neighbor is probably going to want the ability to attend if they don't like what's being proposed or approved. You want to make sure that there's their ability to attend and not having it closed off to the membership. So I would go with the open notice requirements, posting it, allowing people to attend. Lynn asks if there are COVID-19 cases in our community, does the community have to have a sign in front of the community? There's no legal requirement for that. We've had this question come up. I would avoid against, in almost all circumstances, naming anybody. That even if you have firsthand knowledge of it, I would only name the person if they give you consent, specific consent in writing to do it. And the only way I would see them doing that is saying, look, I was in contact, I was in the community on these days, I've been careful, but I contracted it. I'm okay with you using my name because if people came in contact with me, I want them to be safe so they know that it was me that they came in contact with. If you don't have that, I would be careful. I would just say, we've become aware that there may have been a COVID-19 case in our community. You're reminded that you're using your amenities at your own risk. Please abide by all CDC guidelines. That's okay to do that, but you're not required to have a sign saying like we're a COVID-19 hotspot or anything like that. That's not a requirement in any way. All right, I think we had a couple questions in the chat here. Let's see, I'm just gonna go to the chat for a second. Jane asked, was there discussion on opening the community swimming pool and advisability? We did talk about that earlier. You have to take a look at which county you're in terms of what local orders in place, and if you're allowed to. Miami-Dade is closed. Broward and Palm Beach are open but on a limited basis, and the requirement to monitor. The question of that's a permissibility, though, whether or not you have to, it's up to the board, and that comes down to a discussion of risk tolerance and whether or not. And so I would just take a look at the slides there, but without going over everything again. It comes down to there's a risk tolerance, but we are not, as a law firm, we have not been saying, no, you shouldn't open, or yes, you should. That's not something that we've been doing as a law firm, because there's not really a right or wrong answer there. There's a defense for either position that you could take, basically.
Yeah, we don't really think it's our role to sit in an office, dozens of miles from your community and try to tell you what to do, right? We're in the passenger seat, you're in the driver's seat. We have the map, right? We can tell you, hey, if you go down this road, you have some construction ahead, right? Or we can tell you some hazards or some risks, but ultimately it's your job to drive and tell us where we're going, right? And we'll help you get there the best way possible.
So I think Lynn followed up here. She said, we're in the process of having to modernize our elevator and are planning to have an outdoor meeting for the owners, social distancing being maintained through placing cones. I think that's great. If you have a location for that, that satisfies everything. There's no question then about technology and being able to attend. So I think that if you have the ability to do that, that's certainly the best way to go. So that's a great follow-up one. Thank you. All right, so that's what we have for today. Thank you all. You have our contact information. If we can assist with your community as legal counsel, we'd be happy to work with you. We do represent associations across the state. Let me see. Thank you, Lynn. So Robert, if you had anything else before we sign off for today, feel free to do so, and otherwise we'll wish everybody a good day.
Yeah, I'd like to just once again thank you and Jim for providing your time and expertise, all this valuable information, these great webinars to our boards. I know from feedback that they all appreciate it very much. So thank you both again for hosting this and providing this information to all of our clients. I'd also like to thank all the board members who attended this one and the previous webinar, and hopefully attend any future ones that we have planning to be done in the coming weeks or months as this continues. If anybody on the webinar has any questions that were not answered or not asked, please feel free to reach out to me directly at the Boca office, which is 561-245-4444, or you have my email up on the screen. By all means, please send me your questions. Gentlemen, thank you again. Hopefully everybody stays safe.
All right. Thank you, Robert. Thank you, everyone. Have a good day.